All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CR140424, State versus Carol Hanna. We are recording today's proceedings, so counsel, when you step to the podium, if you would please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, and we have conferenced the case prior to argument. So with those preliminaries out of the way, Ms. Cruz, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Virginia Cruz from the law offices of Paul Lankowski, and we represent Carol Hanna, the appellant in this case. As the Court is aware, Ms. Hanna was charged with just one count in this case out of Mojave County, an allegation of illegal voting in violation of ARS 16106A2, and then she was ultimately, obviously, convicted at a jury trial of that count. Ms. Hanna has been convicted of knowingly voting more than once at any election. She was convicted after the jury trial for illegally voting, casting more than one vote in the 2010 general election. After an investigation by the state, the allegations came about that Ms. Hanna had returned a mail-in ballot to Adams County, Colorado.
Counsel?
Yes.
Can you walk us through the process of why she got that ballot in the first place? In other words, I got to believe
yes.
at some point she was in Adams County, correct?
Yes, Your Honor, I'm sorry.
Can you walk us through that?
For the background, Ms. Hanna, for years, most of her life, resided in Colorado. She was a school teacher there, and in, I believe, 2009, she moved to Mojave County, Arizona, to become a school teacher in Kingman, Arizona. After she moved...
She to vote when she came to Arizona.
She registered to vote July of 2010. Okay. So just before the general election in 2010, she went to the DMV, the MVD, and was trying to update her license in a CDL. And while she was there, she took advantage of kind of the one-stop opportunity to also register to vote. And it was brought up in the trial court that Ms. Hanna, when she filled out the registration to vote, to become eligible to vote in Arizona, when she was asked if she was registered to vote in another state, rather than checking yes or no, she did mark that she was not sure. And that came about because Ms. Hanna had always maintained that once she moved to Arizona and wanted to establish the ability to vote here, she continued well into 2012, receiving mail-in ballots from from Colorado for absentee voting. When Ms. Hanna testified at trial, she did explain the measures she had taken to try and stop the mail-in ballots from coming to her in Arizona. She described in 2010, making phone calls, sending an email, and trying to make contact with the elections department in Adams County. But despite her efforts, she did keep receiving mail-in ballots. So Ms. Hanna's testimony at trial was, and even to Agent Burroughs before trial, was that in a final sort of attempt on her part to stop receiving ballots from Colorado, she returned the absentee voting envelope and put a note on the inside of the envelope that she was a resident of Arizona and she wanted to stop receiving ballots from Colorado.
So is it her position then that she didn't vote in that election? She simply returned the ballot envelope with a note in it?
Yes, Your Honor.
So it wouldn't have had a ballot that could have been run through a machine or counted by a poll person, correct?
Correct. That was always her position. And then the difficulty of that was almost proving the negative because, you know, obviously the secrecy of ballots when they're returned, whether at the poll or through mail-in, the process does seem to indicate that once it's received, and I don't know if it's a it was never described in Colorado if it's an automated process or if a person makes note that a registered voter returned a certain envelope. It was never described the process of, again, if it's automated or how that works. But I don't think anyone would dispute that at some point the envelope was separated from anything that would have been inside the envelope. So Ms. Hannah was in the position of almost having to prove the negative of, her statement of, I never returned a ballot. And the state's position has always been, well, she signed the outside of the ballot and she returned it, so it must have included a ballot that was counted as a vote. The only indication from Colorado that Ms. Hannah ever cast a vote by her mail-in ballot was an entry into their voting system that had checked someone had made an entry, and again, it was never clear if it was automatic or by a person entering the data, that she had voted in the general election of 2010.
Do you know how that entry would be triggered?
No, Your Honor.
So if it had just been an envelope received and run through a scanner,
Correct.
it would have been read the same as anything else.
Correct, and that was never...
In fact, you don't know that she didn't have a ballot in that envelope, or you can't prove that she didn't have a ballot.
We cannot prove that she did not have a ballot, correct. And there was, again, no testimony offered. No one from Colorado testified, no one from the Board of Elections there, no one from the Arizona Board of Election. The state had two witnesses at trial. The first witness was the RV park manager where Ms. Hannah was residing in Bullhead City, and she was brought in for the purpose, I believe, just to establish that Ms. Hannah had lived in Mojave County, Arizona for a couple years. And then the only other state witness was Agent Burroughs, a special agent for the state, who had conducted the investigation against Ms. Hannah. So again, it was never clear or established at trial how that entry gets to the Colorado Board of Elections, how it's made, whether it's automated or not.
Can we move from the factual issues to the statutory construction issue about knowingly votes more than once at any election and how you interpret that statutory provision?
Yes, Your Honor, thank you. The difficulty that we had in this case in arriving at jury instructions were there were not clear revised Arizona jury instructions on this section, and in trying to find case law related to other folks who had been charged, much less convicted, of the particular statute that Ms. Hannah was under, just didn't seem to exist. Most of the charges that you see with illegal voting have to do with folks who don't have the ability to vote, whether it's felony conviction or whatnot, to invalidate their right to vote. So when the court gave the standard instruction on knowingly, our position has always been that the state did not meet its burden in proving that Ms. Hannah knowingly voted more than once. Again, her position was always, with her interview with Agent Burroughs and her testimony at trial, that she did not return a ballot in the envelope to Colorado, and that she signed the exterior of the ballot just so they would know it was from her and so that they would open it. She gave testimony, and there was a record that was given as an exhibit where even into 2012, Ms. Hannah had sent a fax letter, which was confirmed received by Adams County and entered into their system, a fax letter that she still needed to be removed from the voting polls there, that she lived in Mojave County, and that she wanted to, again, stop receiving mail-in ballots. And that was 2 years after the general election that she was charged with voting more than once in. And it was certainly before Agent Burroughs ever contacted her about this investigation. So the issue we had, the main issues we have with the conviction against Ms. Hannah is the state not proving beyond a reasonable doubt all the elements of it, not just the knowing mental state, but also more fundamentally what constitutes a vote. And if the jury lost its way in deciding if this was the same election, or if she voted more than once in any election, it was clear from Agent Burroughs' testimony at trial that this was not a general election that included, obviously, a presidential election. There was no testimony that the same office was on either ballot. And in fact, Agent Burroughs, I believe it was on cross-examination, admitted that the majority of the issues that were on the Colorado ballot were of local concern, whether it be property issues or local elections.
But there had to be candidacies for Congress, right?
Yes, yes.
So it was potentially so that if she in fact cast a ballot in Colorado, she could have voted for a candidate for Congress from her district in Colorado, as well as a candidate for Congress from a district in Arizona.
Correct, and that was the state's position of what made it the same.
It seemed to be sound policy not to permit that, right?
It would be sound policy to not allow one person to have more than one vote, correct?
To vote for congressmen from two different districts in two different states.
I would agree with that, yes.
But is that what the statute prohibits?
And that's our issue, Your Honors, is that the statute is not specific on that. The statute merely indicates you cannot knowingly vote more than once in any election, and then election was defined for us, and that's where it comes that it's for the same election for the same office. So again, our main issue in this case was that the statute was not clear, and the direction given by the judge to the jury resulted in an unfair conviction against Ms. Hannah. And I noted in my brief that one of the jury questions that they came back with during the trial seemed to express their confusion with the charge in general against Ms. Hannah, because they were seeking more clarification on if a general election in two separate states would count as voting in the same election or voting more than once in any election. And they also had questions about residency and some other questions, but I think everyone agreed that that was not an issue that they had to concern themselves with. But fundamentally, it was the issue of what does it mean to vote? Is it just returning an envelope? And the defense position was always that that's not enough. You need more than that as an act to vote. I mean, you can't just go to your personal polling place for in-person voting and receive the ballot from the election officials, and that's your vote. You have to take the second step of returning your ballot on your way out, and then it's placed in secrecy into the ballot box. So our position was that just mailing an envelope back to an election official, it does not constitute the act of voting. You have to have also cast a ballot and cast votes.
So did you argue then that the closest thing the state could prove to her having violated this statute was the mailing of the envelope
Yes.
as opposed to the casting of the ballot?
Yes, and that it takes more than just mailing back, which, I mean, the jury didn't side with me, but that was my position, was that just mailing the envelope back was not enough. And the state, and I'm sure they will argue as well today, their focus about the envelope going back was that Ms. Hannah had signed the outside of the envelope, and Colorado had an affidavit regarding that you would not vote more than once in the same election. So Colorado's language on the outside of the envelope, which is an exhibit from the trial and with the court, had different language than Arizona. And so, I mean, even though, again, Ms. Hannah signed the envelope and with that language on it, she was not voting more than once in Colorado. And in fact, she was not voting at all in Colorado. So I don't know if that answers your question, but that was the argument at trial, that, you know, again, kind of making the analogy to when you go in and vote in person, it's not just, you know, I sign in and show my ID and I get the ballot, but I have to actually return the ballot before it's been marked that I voted. So, you know, in case a ballot is spoiled, or I don't know if you become ill or any other reason that you don't return a ballot. So.
Did the state of Colorado ever weigh in on this issue? Did they ever take a position that somehow their laws had been violated? No,
Your Honor.
By her voting here.
No, my client was never charged or even investigated in Colorado, and she was had no other charges, federal or otherwise. It was this one count in this case. So,
thank you.
So again, what we're seeking from this court is clarification on the issue that we think the statute doesn't address. And again, that's the specific definition of voting. And then if this would have qualified, even if the court finds that Ms. Hannah had voted more than once, if this would have qualified as casting ballots for the same office in the same election. I'd like to, if I may, reserve some moments for after the state. Thank you.
Thank you.
Good morning. Krista Rose, representing the state of Arizona, and joined by my colleague, Jana Zinman, this morning. May it please the court. First, I'd like to touch on a few of the points raised by appellant in her remarks. First, the jury considered not only the envelope, which contained an affidavit on it, which avowed, under penalty of perjury, that the envelope contained a ballot, and that it would be the only ballot that appellant would cast in this election. And then,
talking about the Colorado ballot, or are we talking about the Arizona ballot?
we're talking about the Colorado ballot.
So what she sent back to them?
Yes, Exhibit 5 in this case. She swore under penalty of perjury that the envelope contained a ballot. And we also have Exhibit 4, which are the election returns from the state of Colorado, which indicated that, in fact, appellant did vote in that election, the November 2nd, 2010 general election. And so the jury was able to determine, based on Exhibits 4 and 5, that appellant had voted in the Colorado election as well as the Arizona election.
Was there evidence presented as to how that notation would have been made that she voted? Was it based merely on having received an envelope from her? Or was it based on a procedure where somebody actually looked to see if there was a ballot inside?
Your Honor, there is testimony in the record that if appellant had included some sort of note or identifying characteristic along with the ballot, that ballot would have been rejected. But the jury can also make a reasonable inference from Exhibits 4 and 5 that if there's an empty ballot and a canceled stamp on it and it's been mailed to Colorado, and in fact appellant admitted mailing the envelope to Colorado, and that Colorado's official records counted it as a ballot, that it is in fact a ballot. I don't think we would have any expectation that if an envelope was sent to elections officials in any state and it was empty, that a vote would be tabulated. But at a minimum, the statute, which makes it illegal to vote more than once at any election, must mean doing enough so that elections officials will count it as a vote. And in this case, both Colorado and elections officials tabulated a vote for the appellant at the November 2nd, 2010 election.
Well, let's talk about your statement about in any election. Is what took place in Colorado and what took place in Arizona, is that just an election, or are they do each of the states have independent elections?
Well, Your Honor, under 2 U.S.C. 7, Congress, under the Elections Clause of the Constitution, has standardized the date for election to the House of Representatives, and that statute, 2 U.S.C. 7, refers to it in the singular as one election for the U.S. House of Representatives rather than 435 severable elections. So at a minimum, any election must include the same election, but it's broader than that, Your Honor. At the November 2nd, 2010 election, appellant cast 2 votes in 2 different states, and I think it was Judge Thompson's point earlier that it is a sound policy to prohibit that sort of activity.
It is. I think we'd all agree it's a sound policy. The question is whether the statutory language encompasses that, and so the question is this more than once at any election? I mean, there are 2 separate discrete elections with no overlap in candidates or issues, but is the fact that there were representatives, national type elections on each ballot enough to bring it within the purview of the statute? I think that's the real issue I have.
Yes, Your Honor. So
little case law to rest on either way.
That's true, Judge, and I think part of that reason, because this is the first time this court has considered this statute in its 35-year history, and I think the reason is because it codifies something that is commonly understood, which is that...
Define what it is that's commonly understood for us.
What's commonly understood is that we all get one vote. Within broad parameters, over the age of 18, not a felon. If you're otherwise qualified to vote, we all get one vote in one election.
Well, wait, but on a ballot, you've got many issues.
Oh, yes, Judge.
And you only get one vote?
You get one vote in each contested race unless there are multiple candidates, unless you're in a multi-member district of some kind. There may be, but you only get one ballot in an election. One in the primary, one in the general. If there's a runoff, you'll get a ballot in that election. But in a contested race, in a first-past-the-post type of election, like a congressional race or a U.S. Senate race, then you only get one vote, and you're only represented by one member of the U.S. House of Representatives. And so at a minimum, any election must include the same election. And
Same election.
the same election would be an election where ballots are cast for the same office. And under 2 U.S.C. 7, Congress, pursuant to its election clause power, has said this is a singular election. This is one election for the U.S. House of Representatives.
Is the possibility of casting a ballot for a U.S. senator from the state of Arizona the same election as the possibility of casting a ballot for a candidate for U.S. Senate in the state of Colorado?
So the statute, which is the analog to 2 U.S.C. 7, which standardizes the date for choosing senators, is phrased a little bit differently. But 2 U.S.C. 7 is very clear that this is one election to elect the House of Representatives, although the state need not prove that this was the same election because the statute is broader than that. It encompasses the kind of activity that appellant conducted in this case, which was to vote twice at the November 2nd, 2010 election. So the jury considered evidence that this would have been disregarded by elections officials if it had included a note. There was testimony in the record that the same offices were on the ballot both in Colorado and in Arizona, U.S. House of Representatives as well as U.S. Senate races in both states.
So a Senate race and a House race was on the ballot in each state?
The elections for the U.S. House of Representatives were on the election was on the ballot in both states.
Understood.
And there was a U.S. Senate race both in Colorado that year and in Arizona.
Thank you.
If this had been in a presidential year, where we unquestionably have one election to elect the U.S. president, I think this would be a much easier decision, but it would be an absurd result to say that you can vote in 2 different states in presidential years, but in midterm elections, where it's simply an election for members of Congress, you can permissibly legally vote in 2 different states. But this is exactly the sort of conduct that this statute has been on the books for 35 years in order to cure.
One could argue that in a presidential election, we don't vote for a president, we vote for electors.
That's true, Your Honor, which in turn will select the President of the United States. And so you would have more than one opportunity. You would have another opportunity. You would have greater voting power than your fellow citizens who are casting ballots in this election. You're getting 2 votes.
I think we all agree that that's would not be a good policy to allow one person to have more voting power than another. What we're concerned about is what does the statute proscribe?
Certainly, Judge, and I believe it's exactly this kind of conduct, casting 2 ballots at any election. So moving forward, if there are no more questions on that point, as to the question of whether she knew what she was doing. In this case, she simply needed to know that she was sending an envelope, a ballot back to the state of Colorado and voting in person in the state of Arizona. And the record is appellant, I'm sorry?
Go ahead and finish your sentence.
Sure. She simply needed to know that she was doing that. However, in this case, appellant admitted to law enforcement that she would not have voted in Arizona and Colorado in the general election because she knew that that would be illegal.
We've used some words here almost interchangeably, one being an envelope and one being a ballot. That's why I hesitated and I didn't want to have you lose your thought. As I understand it, the only proof that exists is that an envelope was returned, that envelope being the envelope that typically carries the ballot back to the state where the election is occurring, correct?
No, Your Honor. That's Exhibit 5. Exhibit 4 are the official election returns from the state of Colorado, which register a vote from the appellant in the November 2nd, 2010 general election.
A vote?
A vote.
And how is that registered?
It's through the normal procedures that Colorado uses to register votes. Colorado's elections officials receive millions of votes at an election, and they determine the eligibility of the voter, the validity of the vote, and they process it and count it toward one candidate or another, or toward one ballot question or another. And so you have Exhibit 4, which are the official records, which have determined that she has voted, and then Exhibit 5, which is a ballot where she swears under penalty of perjury that the ballot that the envelope contains a ballot, and that carries a canceled stamp on it, and she admits having sent it back to Colorado.
But denies having put the ballot in the envelope.
Well, Your Honor, she made a number of statements.
And all I'm trying to get down to is her position.
Yeah, yes, Your Honor, and it evolved throughout her various statements in this race. So when she initially speaks to law enforcement, she says, there are no circumstances under which I would have voted twice at the general election in Colorado and Arizona. I know that's illegal. And then the special agent presented her with a copy of the envelope, and she said, well, that's my signature, you know, that's mine, but if I sent it back, I would have written a note on the ballot or maybe included a sticky note on the outside, or I would have written on the outside, I would have marked it in some way to indicate that I don't vote in Colorado anymore and to stop sending me ballots. So there are various iterations of her pretrial statements to law enforcement, which were audio recorded and played for the jury, followed by her testimony at trial, which was a return to her first position, which is that she did not vote in any way, shape, or form in Colorado in the 2010 election. So there were a number of different statements. So the jury had substantial evidence to consider when making their determination that appellant had voted both in Colorado and in Arizona at the 2010 general election. The jury was properly instructed in this case that any election is those in which ballots are cast for the same office. In this case, she was voting for U.S. House of Representatives twice, or at least had the opportunity to vote for U.S. House of Representatives twice, in two different U.S. Senate races, and thus ran afoul of the statute. If there are no further questions from the court.
Is this a recurring issue, or is this sort of a one-off case that has unusual facts?
Well, Your Honor, the record is silent as to other prosecutions. From personal knowledge, these cases are prosecuted. However, this is the first, to my understanding, that went to trial, and it's certainly the first that's appeared before this court.
And I'm asking purely for reasons of, we talk about when we should publish, and sometimes when we interpret a statute, we deem that worthy of publication. But I've never seen this fact pattern in 18 years on the bench, so I don't know if it's just something that's odd and an outlier or something that possibly would recur.
No, Your Honor. I think there should be a published opinion in this case from the state's perspective. State's election officials are only getting better at detecting the sort of conduct that you see in this case, at sharing information. In this case, appellant was matched. There's a three-part match between Colorado and Arizona: appellant's name, birth date, and social security number. Further investigation determined matches between her email address, P.O. box, physical address. There was an in-person ID at trial that tied her to her residential address. There's an undisputed exhibit in this case, which is her Mojave County voting record and her voter registration, and then her fax that she sent in 2012 to Colorado elections officials, in addition to her trial testimony that she was in fact the Carol Hanna who spoke to law enforcement in the audio recording that had been played for the jury. And so investigators are only getting better at identifying this sort of conduct. These cases are ongoing, being prosecuted on an ongoing basis. But generally, I think the reason this court's not confronted this important issue is because it codifies common sense. In one election, you get one vote. You get to cast one ballot. And you stand equally with other citizens who are qualified to vote in that election. None of us have a greater weight at the ballot box than anybody else.
You said these are being prosecuted on an ongoing basis. Are there other cases such as this in your agency at this time?
Yes, Your Honor. Yes, Your Honor. Any further questions?
I'm wondering, apart from to the extent we might criminalize multiple voting, are there provisions in either Colorado or Arizona that would allow election officials to disregard a ballot that they felt was multiple?
Certainly, Your Honor. And as part of the same statute, it also criminalizes casting multiple ballots in the same election.
And now I'm talking about it as opposed to punishing the person who does it. Is there a provision that allows an election official to say, I'm not going to count this ballot because this is the second ballot cast by that person?
Yes, Your Honor. However, this statute is important because it needs to have a deterrent effect. This sort of activity is very, very difficult.
Do both Colorado and Arizona have provisions?
I can't
like
speak to Colorado, but in Arizona, if election official had reason to believe that someone had already voted, they can set aside that ballot for further investigation, and there would be a determination made as to whether it should be discarded.
In this record, is there any evidence as to what Arizona did, if anything, about the ballot cast in Arizona?
Well, Your Honor, it happens too close in time. So she postmarked a ballot. Colorado received her ballot on October 28th, and then she votes in person in Arizona November 2nd. And so you've got millions of people participating in the election in Colorado as well as the election in Arizona. And so to be able to detect this sort of conduct, to be able to compare information between Colorado and Arizona, it'd be next to impossible. So that's why this statute is important, because it deters, or should deter, this kind of conduct. Now,
So there's nothing in this record that says whether the ballot cast in Arizona by Ms. Hanna was counted or not?
there is, Your Honor. There are I believe it's Exhibit 8. There are the voter returns from Mojave County, as well as the signature roster, which is a separate exhibit. I believe it's Exhibit 10. It's a signature roster where she signed in at her polling place, and the official election returns of Mojave County indicated that appellant voted in Arizona at that same election.
I think I'm not being clear. What I'm wondering is, when a person has actually successfully cast a ballot that's been counted, and election officials learn later that perhaps that person voted twice, is there a provision for striking the ballot?
Your Honor, I completely understand your question. So to vindicate the important principle of voter anonymity, when you have voted by absentee or via mail using this envelope that identifies who you are.
That's kind of an important distinction. It used to be there was only absentee balloting. I mean, you went and voted. I live in Flagstaff. I don't think I've gone and voted in person in years, but it's a mail-in, which is common now, and I can see some of the problems that arise, but go ahead.
Yes, Your Honor, and before I forget to Judge Downey's important point, I think this is another reason we may see more of these cases. As voting by mail, voting absentee becomes easier and easier, you have the ability to cast ballots in multiple states or in jurisdictions where you don't reside or aren't permitted to vote. It just becomes easier for someone who's willing to do that. So to vindicate the important principle of voter anonymity, when you send your ballot back, it's detached from the envelope because the envelope identifies who you are and the ballot indicates who you voted for. And so those are separated immediately to preserve voter anonymity.
So the only way that the actual vote that a person would have cast could be challenged would be if it's challenged at the time the ballot's actually received and before it's counted.
Yes, Your Honor.
You can't go back after the fact somehow and subtract one vote from some candidate or another.
You can't, Your Honor. And in appellant's very congressional district, there was I think it was 2012, there was a congressional primary settled by 14 votes. And so once
that's why you're arguing about the need for deterrence, because the only real remedy for multiple voting is to deter those who might do that.
Yes, Your Honor. There's no way to eliminate her vote after the fact. Once you've done so, you've successfully diluted the voting power of voters who properly voted in an election.
Before we let you go, back on the matter of the statute, which is 2 U.S.C. Section 7, it reads, the Tuesday next after the first Monday in November in every even-numbered year is established as the day for the election, comma, in each of the states and territories of the United States, comma, of representatives and delegates to the Congress, etc. You could read that to say that there is an election in each of the states and territories of the United States.
Your Honor, the states, and if the court adopted that interpretation.
So you referred to it as one election, but you could read it as being one election in each state.
Yes, Your Honor. My read of 2 U.S.C. 7 is that Congress has standardized the election for members of the House of Representatives. However, this statute doesn't simply prohibit voting twice in the same election. It prohibits voting twice at any election. And so that even if this were read as plural rather than singular, appellant's conduct would still be reached by this statute.
Counsel, you've said that you're currently pursuing a number of these cases. Are those cases to your knowledge, involving multiple votes within the state of Arizona, or are there additional cases regarding of someone voting in the state of Arizona and in another state?
Sure, Your Honor. And
Are
this
you
is
saying yes, there are other states involved in other cases?
Your Honor, I know that my office has prosecuted cases in which people have voted in multiple states.
Thank you.
Now, there are a number of provisions. This is a statute that covers a wide range of electoral misconduct. So not necessarily voting twice at any election. There are other provisions that are covered. But it is.
For example, if you are not qualified to vote, it's a crime, is it not, to vote?
Yes, Your Honor.
So you could have a situation where a person votes in two places and is not qualified in one. And I'm assuming that under most circumstances, if you're qualified to vote in Colorado, you're not qualified to vote in Arizona. Is that fair to say?
That's true, Your Honor. Every jurisdiction in which I'm aware insists on exclusivity when it comes to voting, that if you're going to be voting in Colorado, you can't vote in Arizona.
But the qualifications to vote are determined by each state, correct?
Correct.
Is it possible that in some states it's determined by property ownership and other states by residency?
No, Your
I'm assuming
Honor.
most places it's residency.
Residency is the test, Your Honor. Property ownership has been, you're putting me to the test here. I believe it's a Supreme Court decision and not the VRA that has eliminated property ownership as a qualification for voting. And then, of course, you've got the federal parameters, age of 18, no discrimination by race or gender. But that would be prohibited. And if there are no further questions,
Thank you.
thank you.
Rebuttal, Ms. Cruz?
Thank you, Your Honor. And I want to start in response to the state's indication to this court that there was testimony regarding the procedures in Colorado and how Exhibit 4, which noted Ms. Hannah had voted in Colorado, was generated. To be clear to this court, there was no testimony offered of how that process happens. So there was no way for us to know out of what came out of trial what Colorado's procedure is when they receive a mail-in ballot.
Is it possible that the mark that counsel addressed as far as the recognizing that she had voted came off of the receipt of the envelope and the barcode on the envelope as opposed to the barcode on the ballot itself?
And yes, and that was the defense position. There was no indication what a ballot in Colorado even looked like, much less if a ballot in Colorado had a barcode, or when a ballot was received by mail. And again, the privacy, I don't think anyone disagrees with, that the need for privacy is to separate an envelope from a ballot, but it is not clear if the indication that someone had cast a vote comes from scanning the envelope, or if it's from the separation and then right away the ballot is scanned into a ballot box or noted by a ballot worker. So again, the defense position was always that it was just as likely that it was just from the envelope being returned. And again, the state having the burden to prove that Ms. Hannah voted more than once never established how a vote was counted in Colorado and what triggered a vote, them finding that a vote was made. And I think that's, again, one of the major problems with this case under the statute is there's not a clear record in this case of how Colorado ever determined that Ms. Hannah voted more than once. And I know, Judge Thompson, you had questions that the state responded to regarding Ms. Hannah voting in Arizona. And so the court's clear. Ms. Hannah never denied voting in Arizona. She admitted freely that she went to the ballot and voted in person in Mojave County in the general election in 2010. And I think the state kind of misstates Ms. Hannah's statements that she made to Agent Burrows. To be clear, Ms. Hannah only spoke with Agent Burrows by phone twice before she was charged in this case. The very first time was more than 2 years after she had voted in Arizona, and she got the out-of-the-blue kind of cold call from Agent Burrows, and she had no idea what she was talking about. And so she gave some general statements to Agent Burrows at that time that are obviously were recorded, where she made statements like, I would never vote more than once. You know, I voted my whole life. I've been registered to vote since I was 18, things along those lines. And this is a lady who's in her 60s now who has never had contact with law enforcement before her phone call with Agent Burrows in 2012. And she's someone who was a retired school teacher. So when she's making statements to Agent Burrows by the second phone call, that triggers her memory of, and kind of going back to her teacher background of being detailed and note-taking and things like that, that triggered her memory of, I mailed this back, this envelope, because by the second conversation, Agent Burrows had forwarded her by email a scan of the envelope so that they could have a more informed discussion about what Agent Burrows was even discussing or asking Ms. Hannah about. So once Ms. Hannah had reviewed that, she got back on the phone with Agent Burrows and she made the statement, which was consistent with the first statement she made to Agent Burrows, that she would have never voted more than once in any election. She didn't vote in Colorado in 2010. And when she mailed back the envelope and when she saw the envelope that Agent Burrows has provided, that triggered her memory that the only reason she mailed it back was to include a note. And she detailed with Agent Burrows, as she did at trial, the effort she had made in 2010, 2011, and 2012 to try and get Adams County to stop sending her absentee ballots, because now she was a resident in Arizona and had every intention of only voting where she resided. She was no longer a property owner in Colorado. I mean, she had no interest in Colorado elections or things of local concern up there. And I know the state's argued more than once, made the statement, you know, that this is a common sense thing, and that's their position of why this court has never heard an argument on this. But I would also encourage the court, if you're inclined, to publish its opinion. The jury in our case, it's not so common sense. The jury in our case was confused about the statute. The attorneys and the judge struggled with language for a jury instruction to help clarify for the jury. I have no idea about the statistics of the number of folks that are similarly situated, like Ms. Hannah found herself, where software through the state matched her name, in multiple states. I have no idea if most of the prosecutions have to do with Arizona elections. That would seem to be the thrust of the statute in Arizona, is to prevent folks from voting in more than one polling place in their local elections, or voting in more than one race in Arizona. But ultimately, we're asking the court to decide this conclusively, not just for Ms. Hannah, but for anyone who might find themselves in the same position as Ms. Hannah. And we'd ask the court to remand this for further proceedings. Thank you.
Thank you. Thank you both for your presentations. They were very helpful. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.